It is wonderful to be here. What an honor. And to be here with two of my former colleagues, Peggy Little and Kara Rollins here, who I've had the opportunity to work with both of them when I was with NCLA. You know, as a trial attorney, primarily focused on fighting back against federal regulatory overreach, I had an opportunity to try a lot of different cases in a lot of different areas, primarily focused in water and natural resources, but also on the constitutional side of things. But when I came to NCLA, my entire life kind of changed in truly getting a much better understanding of how pervasive and how truly insidious our regulatory and administrative regime has become. I had an office right next door to Peggy. We spoke probably almost every single day that I was back here in DC at NCLA about new things that were coming down from agencies. And one day I was visiting with Kara, and she made the comment that if you want to be a constitutional attorney, this is really the only area of the law where you will be dealing almost exclusively on constitutional issues. And one of the most important aspects of that is the court system itself. The Constitution, obviously, under Article 3, provides for district courts. That's how our legal system was set up, was under Article 3. But over time, these various agencies, through executive action, have created these administrative law courts and administrative law judges. And for those of you here in the room who are familiar with that, you also recognize that these agencies are much more successful when they appear in front of an ALJ than when they appear in front of an Article 3 judge. And as someone who tried numerous cases against agencies, I can assure you that even in Article 3 judges, you're always starting out where every single person in the room, including the person in the black robe, is on the other side. I learned very quickly when taking on the EPA or the USDA or the U.S. Forest Service or the U.S. Fish and Wildlife Service that any case that I had to overtry. So if I needed 15 witnesses to make a point, I would call 30. If I needed 27 exhibits to make my point, I would bring in 67, whatever the numbers were. I had such an incredible burden of proof to overcome the belief on behalf of even the Article 3 judge that whatever the agencies did was the correct thing. That one of the last cases that I tried was a lawsuit where a gentleman had moved an irrigation ditch on his property, affected 2.1 acres of land. The EPA and Corps of Engineers came in and concluded that that irrigation ditch was a navigable water of the United States, asserted jurisdiction over it, claimed he needed a 404 permit in order to clean out his irrigation ditch, and brought an enforcement action against him. When we went to trial, he was facing penalties of almost $65 million because at that time, the EPA could impose penalties of $37,500 a day. It's now over $59,000 a day, which is used by these agencies as a way to force you into a settlement, whether you have actually done anything wrong or not. But what happened in that case, and why I think it's important for understanding that even in Article 3 judges, you've got an uphill battle at times. The court concluded that it was my burden of proof to show that my client had not violated the Clean Water Act. It was not the EPA's burden of proof. It was my burden. So in these cases, the courts are even flipping the burden of proof of who's responsible for proving the case. When the judge made that determination, because obviously it was an enforcement action, we all assumed that the federal government would go first, present their case, and I would respond. When the judge ruled on a motion in limine that I had the burden of proof, I demanded that I then be able to go first, and I be able to present my case first. The EPA and Corps of Engineers were not expecting that kind of a move. Their first response was, oh my gosh, we need to set the stage. We're the ones that we need to be telling the jury what is what and how this all came about. And I'm like, no. If I have the burden of proof, I go first. And it allowed me to crush him in that case. And after a 2-week trial, the jury was out for 2.5 hours, and we ultimately won. But what I'm saying is that ALJ, being in a regular district court because of Chevron deference and the various deference doctrines, we already are starting, with not being on an even playing field. When you take it before administrative law courts, it becomes even a worse situation. And I know that Kara and Peggy both have had personal experience with this. You know the successes of NCLA, what they have been able to do in such a short period of time. I believe you have 3 cases up before the U.S. Supreme Court this term, maybe 4 cases so far this year. And they have tried these cases and why people should be litigants and the targets of federal regulatory action should be able to proceed in an Article III court versus an ALJ or an administrative law court. One of the things that we learned while I was still with NCLA is I believe it was the SEC where the ALJ side of the ledger was actually working with the litigation side of the SEC, which was quite a scandal for a very short period of time. But that demonstrates, I believe, that ALJs are not the independent arbiters that they claim to be. There are several things that I am trying to do as a member of Congress. And I would say my number one priority for my tenure in this role, no matter how long it is, has got to be regulatory reform and reform of the Administrative Procedure Act. The APA was adopted in 1946. It has never been amended. But again, as someone who has had to work in that realm in litigation for the last 25 or 30 years, I can assure you that the APA desperately needs to be amended. I am on in terms of my committees, as you noted, I am on the Judiciary Committee, but my subcommittees on judiciary are administrative law and antitrust. And another subcommittee is Constitution and Limited Government. And then I am also one of the only freshmen on the Select Committee on the Weaponization of the Federal Government. In terms of our administrative law subcommittee, that's overseen by Thomas Massie from Kentucky. He's the chairman of that particular subcommittee. And I went to him very early after I arrived here and said, one of the most important things we can do is revisit how rulemaking is done, not only how rulemaking is done, but how litigation is done in the administrative context. As we all know, and especially if you're someone who works for oil and gas companies, gravel companies, farmers, ranchers, some of the more disfavored industries right now, even though they're the ones that produce everything, it is very important that we have standing to challenge some of the things that are done in agencies. And that's an area where, especially in, say, the Endangered Species Act context or the NEPA, National Environmental Policy Act context, it can be so extremely difficult to get standing to challenge rules and regulations that may destroy your ranch or may destroy your ability to pursue oil and gas development or may shut down your gas station. Even though you would think that you would have the ability to challenge the listing of a particular species if it's found on your property, should you pursue that challenge through an economic lens, the courts will oftentimes say you don't have standing to challenge this because that's not one of the issues we can take into consideration. So right now, and since I've been here, one of the things I've been working on is either standalone bills or a comprehensive package. We haven't decided yet what we're going to do, but we are planning on doing an administrative law reform. And I invite all of you, everybody in this room, if you have ideas of ways that you think that the process or that the APA should be amended, I invite every single one of you to get a hold of my office with your ideas. I've reached out to NCLA. I've reached out to a variety of organizations, CEI. I've reached out to folks and said, I have no pride of authorship here. I want to get this right. And one of the things that Peggy suggested that we do is that right now it is only the agency that gets to determine if they're going to use an ALJ. So if they want to drag Kara before, if they want to bring an enforcement action against her, they can choose to go into an Article III court or before an ALJ. Well, how about if we just level the playing field? It doesn't get rid of administrative law courts or administrative law judges, but it lets Kara make the decision as well. So in the Cochran case, for example, as that case proceeded, then she would have been able to say, I don't want to be in front of an ALJ. I'm going to make you go into an Article III court. And I think that move alone will substantially limit the kind of enforcement actions that these various agencies bring. because right now they don't have any risks associated with bringing these cases. But if they're going to get bad case law, if they're going to get bad decisions out of an Article III court versus an ALJ, they may think twice before bringing that action. So that's just one of the areas in which I think that reform is drastically needed. One of the other things that I have done and that I have learned about since I have been here, and I actually had the good fortune of engaging in an oral argument today as a member of Congress, which we don't normally get to do, and maybe I shouldn't describe it that way. But the USDA is still attempting to force our livestock producers, our cattle producers, to use radio frequency identification ear tags. And I've been fighting them on this for 5 years. It's another form of surveillance. It has a price tag of probably anywhere from $500 million to $2 billion. We filed a lawsuit at NCLA, got it blocked, but they're back trying to do it now with a new rulemaking. But we asked for a hearing before OIRA and to explain why they should not allow this rule to go forward. And we had the arguments this morning at 10 o'clock, and we argued it from two standpoints. One was from the standpoint of that the rule is not necessary, that we have the highest quality meat and livestock in the entire world. We have very little by way of disease outbreaks in our country. But the other part was that they have failed to follow the policies. They have failed to follow the APA and the other executive orders related to rulemaking. And I thought that the argument went very well. I was extremely excited about it. It was fun to get back into that kind of a venue, although I was just sitting at my desk on the telephone. But I have missed engaging with something like that, where you actually get to present an argument and take questions and things. We'll see what OIRA does. But what we've pointed out is that with this rulemaking, they have failed to adequately assess the cost. They have failed to follow the federalism requirements and those sorts of things. So with that, I think it's probably best to just open it up to questions and focus on what your issues are. Again, as a member of Congress who has worked in this area for 25 or 30 years, I really do welcome your input as to ways in which Congress can fix the situation that we're in right now, because I don't want to be doing it, toggling back and forth between administrations and executive orders and withdrawing executive orders and issuing new ones. We need stability and certainty in this area. Our litigants, our citizens deserve it. And I would like to actually accomplish something in this space that is good for the American public, because administrative agencies, regulatory agencies have become so pervasive in controlling every aspect of our lives that we have to make sure that we have an equal playing field, an even playing field, that people get the due process that they're entitled to, and that they have a chance of presenting their case, not just to an Article III court, but even if there are going to be administrative law courts, to ensure that that is going to be a fair proceeding when it does go forward. So again, with that, I'd be happy to take any questions that you all have.